The Supreme Court's silent restructuring of India's gig economy safety net. How one labor. The old playbook just got more expensive to run. Teams that rebalance timing, tooling, and supplier mix pull ahead quietly. We trace cause, incentive, and downstream impact in order. But it just stripped 28 to 35 million gig workers of legal labor protections and triggered a three-domain crisis in health insurance, tax compliance, and regulatory reform. For 48 years, Indian labor law relied on the Bangalore water supply precedent. It defined industry broadly, any enterprise with capital, labor, and coordinated economic activity. That umbrella protected contract workers, piece rate workers, and platform-based gig workers. A delivery driver for Swiggy, an Uber driver, an Oyo housekeeping staff member, they could all claim statutory protections under the Industrial Disputes Act. The company couldn't arbitrage away from labor law by calling them independent contractors. The 2020 Industrial Relations Code narrowed that definition. Industry now requires systematic production or supply with recognizable continuity. A delivery driver completing 3 to 4 orders per day doesn't fit. They're episodic transactions, not continuous industry. On August 21st, the Supreme Court validated this narrowing, saying the legislative intent was clear. That judgment closed the legal door that had stayed open for nearly 5 decades. Now here's where it cascades. First, health insurance. India's health coverage is built on 3 pillars: employer group policies covering 70 million salaried workers, state schemes like Ayushman Bharat covering 300 million poor households, and retail individual policies covering 50 million affluent self-employed people. Gig workers fell into a fourth zone: ambiguous, uninsured, and caught between income thresholds. With the Supreme Court judgment, platforms face zero legal obligation to extend employer coverage. Workers are now pure self-employed, and self-employed health insurance for delivery work carries 15 to 40% annual premium increases. Most gig workers get priced out entirely. But here's the institutional play. Insurance startups and established players like HDFC, Digit, and Manipal Cigna have an 18-month window to build micro-benefit products for the newly uninsured gig cohort. A 200 to 500 rupee per month critical illness policy bundled with accidental hospitalization could capture 8 to 12 million users. The regulatory friction is gone. Workers aren't statutory employees anymore. Bain estimated India's health insurance gap at $40 billion in 2024. Gig workers account for 8 to 12 billion of that. That's a venture-fundable problem, and the clock just started. Second, tax policy. Under the old Bangalore water supply logic, a gig worker could claim salaried status for income tax purposes, qualifying for the 50,000 rupee standard deduction and 1.5 lakh rupee tax advantage savings under Section 80C. The Income Tax Department tolerated this ambiguity because median gig earnings were modest, 1.2 to 1.8 lakh rupees per year. Now the tax department has legal cover to reclassify gig workers as self-employed. Self-employed income faces higher compliance burden, GST registration if turnover exceeds 40 lakh rupees, tax audit obligations if gross receipts cross 10 lakh, and loss of salary deductions. What's coming next is a circular from the Central Board of Direct Taxes, likely within 6 to 9 months, signaling stricter enforcement. That circular will likely trigger a push to recover back taxes from gig workers who've been using salary deductions for years. We're talking 8,000 to 15,000 crore rupees in potential recovery. Tax software companies, fintech platforms, and compliance tools will see demand spike. But the gig workers' tax burden just got much heavier. Third, and most consequential, is what this judgment signals about labor reform velocity and judicial alignment with the Modi government's ease of doing business agenda. This isn't random. In late 2026 and early 2027, the government will likely push new labor reforms, raising the threshold for fixed-term employment from 120 days to 180 to 240 days, weakening collective bargaining thresholds for startups, allowing hire and fire flexibility for companies under 50 lakh rupees turnover. The Supreme Court judgment de facto gave those reforms a green light. International investors in Indian platforms.